Online philosophy assignment help. For any help regarding philosophy homework help, visit https://www.lahomeworkhelp.com. https://www.lahomeworkhelp.com. Email info@lahomeworkhelp.com, info@lahomeworkhelp.com, or call us at +1 678 648 4277. 1. Explain Rawls' distinction between practice rules and summary rules, giving examples of each. Then explain why Rawls thinks that someone who wants to perform an action governed by a practice rule can't meaningfully ask whether or not he should follow the rule in this case, if he accepts that the practice as a whole is justified. Why does Rawls think his distinction can be used to defend the utilitarian theory of punishment against the charge that it would condone the punishment of an innocent man, if doing so would produce the most welfare? Is Rawls right? 2. In On Liberty, Mill writes, he only purpose for which power can be rightfully exercised over any member of a civilized community, against his will, is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. P. 251. In support of this claim, which has been called the harm principle, Mill seeks to establish that mankind are greater gainers by suffering each other to live as seems good to themselves, than by compelling each to live as seems good to the rest. P. 253. Explain and evaluate Mill's arguments for this view. Do you think Mill's harm principle is correct? Do you think he can successfully defend the harm principle on the basis of utilitarian considerations alone? Why or why not? 3. When, if ever, is the state justified in restricting the liberty of those subject to its laws for their own good? LaHomeworkHelp.com. 4. Scanlon's Millian principle governing freedom of expression says, there are certain harms which, although they would not occur but for certain acts of expression, nonetheless cannot be taken as part of a justification for legal restrictions on these acts. These harms are a. Harms to certain individuals which consist in their coming to have false beliefs as a result of those acts of expression. b. Harmful consequences of acts performed as a result of those acts of expression, where the connection between the acts of expression and the subsequent harmful acts consists merely in the fact that the act of expression led the agents to believe, or increased their tendency to believe, these acts to be worth performing. P. 213. Explain this principle, and explain and evaluate Scanlon's argument for it. Give an example of a government regulation of expression the principle would condemn, and an example of a government regulation of expression the principle would allow, and explain how the principle applies to each case. Do you think the principle is a good one, that is, that it protects and restricts freedom of speech in the right way? Why or why not? In defending your answer, be sure to consider potential counterexamples to the principle, cases of acts of expression the principle protects, or allows to be restricted, which someone might argue ought not to be protected or restricted. 5. Carefully explain and assess Langton's argument that pornography violates women's right to free speech. 6. Shauna Schifrin claims, there seems to be a harm/benefit asymmetry built into our approaches to hypothetical consent where we lack specific information about the individual's will. We presume, rebuttably, its presence in cases where greater harm is to be averted. In the cases of harms to bestow greater benefits, the presumption is reversed. P. 131. LaHomeworkHelp.com. Explain Schifrin's reasons for this claim. Does her argument work? Why or why not? And, in light of your discussion, what should we think about Schifrin's opening question? Should a child be able to seek compensation if she suffers from a painful, chronic illness brought about by her parents' procreative negligence, even if she has a life that is well worth living on balance? Be sure to defend your answer against possible objections. 7. The British historian Thomas Macaulay once defined a lawyer as someone who would, with a wig on his head and a band round his neck, do for a guinea what, without those appendages, he would think it wicked and infamous to do for an empire. 1. Does the role of the lawyer require her to do things that it would be wrong for her to do if she were not a lawyer? And, given that she is a lawyer, can those actions be justified? Be sure to defend your answer against possible objections. LaHomeworkHelp.com. Introduction. In Paternalism, 1, Gerald Dworkin asks whether or not the state is ever justified in restricting the freedom of a person strictly for their own good. Dworkin thinks the state may be justified in cases where the person is acting irrationally. This paper examines this claim. I begin by defining paternalism and provide a preliminary argument against it. I then examine Dworkin's proposed justification for paternalism and its implications. I end by providing my own paternalistic principle, arguing that paternalism can only be justified in a very limited set of cases. I believe the extent to which paternalism can be justified is much more narrow in scope than what Dworkin's theory implies. Paternalism breatharianism is the belief that food and water are not needed for survival. People adhering to this lifestyle believe that only spiritual forces and sunlight are required to sustain life. A Swiss woman practicing breatharianism recently starved to death. 3. Should the state be allowed to stop people against their will from participating in self-destructive lifestyles such as breatharianism? Such a law would be paternalistic. Paternalism is the interference with a person's liberty solely for that person's benefit. This does not include restrictions intended to protect people from secondary harms. For example, restricting breatharianism to prevent others from being encouraged to participate would not strictly be paternalism. It would be paternalism if the only goal was to protect the health of a person who wanted to try it. Deciding whether or not paternalism is justifiable requires weighing the importance of allowing a person to make their own decisions against the duty to protect a person's well-being. LaHomeworkHelp.com. Paternalism does not include laws that require a person to be informed. For example, requiring that a person be informed about current medical opinion regarding breatharianism would not be a paternalistic law. Such a law does not restrict the person's liberty, but rather aims to provide relevant information so the person can make an informed decision. Anti-paternalism. It can argue that paternalism is generally not justifiable. Arguments that reject paternalism appeal to the importance of autonomy. Autonomy is a person's ability to act according to their own reasons without external intervention. It encompasses the idea that each person is ultimately in the best position to judge what decisions they should make. Paternalism denies a person their right to autonomy. It is perfectly fine to inform a person and persuade them to make particular actions. Dworkin's paternalism. Dworkin thinks paternalism can be justified in cases where the person is acting irrationally. He uses the example of a paternalistic seatbelt law. I decide to not wear my seatbelt. I fully appreciate the risks and truly value convenience above anything else. In this case, a seatbelt law cannot be justified. However, I may decide to not wear my seatbelt because I am acting irrationally. I don't fully appreciate the potential harm involved and weight it inappropriately when comparing it to potential convenience. If I were given time to reflect, I would decide to wear my seatbelt. LaHomeworkHelp.com. Dworkin believes that in the above cases, a paternalistic seatbelt law is justified and does not conflict with my right to autonomy. My rational self would choose to wear a seatbelt. That is my actual preference. The seatbelt law enforces my autonomy. The law allows me to fulfill my rational autonomous desire to wear a seatbelt. Dworkin's paternalistic principle can be summarized. Paternalism is justified when a person makes a decision that imposes substantial risk which they would not make in a completely rational and informed state of mind. The pragmatic argument. The easy response to Dworkin is to reject his claim on pragmatic grounds. Dworkin says that the burden of proof lies with authorities. It is up to the state to prove that the person being restricted is acting irrationally and in a substantially risky manner.